So this chapter is more like a trailer for the entire other module. So that's the reason I'm skipping a bit, because most of the topics will be elaborated in separate modules, right? So I hope you all got that idea. So legitimate use, we have 9 legitimate use. I have summarized all these things into 9, right? So basically, the legitimate uses are in line with what we call the 6 lawful basis except consent, right? There are 5 lawful basis except consent, right? More or less, to certain degree maps to that, right? So the first legitimate use is if the data principal has voluntarily provided the data, right? So if a person voluntarily wants to do a transaction, they want to provide their data on their own, then they're free to do that, correct? This is what I told you, like someone giving an advertisement photo shoot, or they're giving their information out, they are always free to do that. An organization can, for example, if I go and try to purchase something, and in the context of that I give a data, right? So this is where your contract, which we usually refer in GDPR, is mapping. That's where it is getting mapped. But it's still again very interesting how organization can misuse this voluntarily provided data clause, because it's very difficult to prove what is voluntarily and what is not voluntarily given. So these are the areas where we see lot of ambiguity is going to be created in the future, where one person says I didn't give it voluntarily, company says no, it was voluntarily provided. So those arguments will definitely come before we reach a maturity. uh, State, we're not going to discuss much. It's a government can collect the data for providing benefits, subsidy, service, and for obligation of the law, rule of law, performance of obligations of the state. So all these things are quite common everywhere around the world, not much to discuss there. So again, compliance with judgment or degree or order, that's again straightforward. Responding to medical emergency, this is what we call vital interest. And also providing medical treatment or health services under pandemic, this could also relate to vital interest and some extent of public interest as well. And the next is to ensure safety, and also in terms of this also relates to your public interest, like in terms of disaster or like COVID like situation, right? This also relates to public interest predominantly. The last is about your purpose of employment, or those relating to safeguarding the employer from loss or liability. So this broad definition is that if you are processing personal data for employment reason, then most probably you will be exempt, right? From most, because the moment you say legitimate use, you don't need consent, or any of data subject rights could also be sort of discounted, right? So that's where the law has given a very broad category that if you are processing for employment reasons, then most of the components of your DPDP Act will be out of the scope. So it's more like they took away the employee's personal data rights out, or the power of employees questioning their own organization is almost diluted to good extent in the DPDP Act. Whereas if you see in the GDPR, the it could be your customers or your employees or your third parties, all are equal in front of the GDPR law, right? But here it's like more to do with your external customers, right? That's where the law has favored a lot. But internal employees, such broad statement can easily be used for different reasons, and it's slightly becomes unquestionable under the DPDP Act at this point of time. All right.